Okay, good afternoon, everybody. I'm just making sure I'm set up on Facebook and Instagram. Okay, we're good to go on Instagram. Okay, so good afternoon, everybody, and happy Friday. Thank you for tuning in today to our live broadcast. I am going live on Facebook and on Instagram. Those of you who are going to be tuning in on Instagram today, I do encourage you to hop over to our Facebook page because I'm actually going to be having the subtitles and everything, and it'll be a little bit easier to follow along. But if not, you can stay on Instagram, and I'll post the link to this if you want to see it with the subtitles and everything on our Facebook page, or you can check it out on our YouTube page. Okay, today I'm going to be discussing tips on how you can successfully get joint custody. My name is Attorney Joy Farrell. I am the managing attorney here at the Farrell firm, and we are located in Tucker, Georgia, right off of 285. Here at the Farrell firm, we have a heavy focus on family law litigation, which entails divorce, child support, custody, adoptions. We also do wills, power of attorneys, and personal injury. So if you've been injured in an accident and you were not at fault, you can feel free to give us a call about that. If you want to know more about myself and our team here at the Farrell firm, you can head over to our website at farrellfirm.com, and you can choose to stay connected with us by following us on Facebook, on Instagram, and you can keep up with us via our YouTube page. And our YouTube page is actually under my name, which is Joy Farrell. So by tuning in today, you acknowledge that the information I'm giving you is for informational purposes only, and the information given is based on the laws of the state of Georgia. Every case is different, and every case requires specific legal advice. So if you are in need of specific legal advice, I encourage you to contact an attorney. You can contact us here. We'll give you that information at the end, but you would need to seek a private consultation. And you also understand that by tuning into this broadcast, we are not creating an attorney-client relationship. So with that being said, we can go ahead and get started. So the first thing I'm talking about, what is joint custody? As I state in all of these videos that I do week after week, there are actually two types of custody. Those two types of custody are your legal custody and your physical custody. Legal custody is the ability for you to make decisions regarding your child, like school, and medical decisions, while the physical custody is actually the determination of who the child will live with. And again, you see me looking back and forth because I'm on Instagram and I'm on Facebook. In custody cases, you can be awarded different variations of custody. It can be joint custody, sole custody, or primary physical custody on the physical side. Today, we're going to be focusing simply on the physical custody aspect, not the legal custody. Physical custody, as I stated before, is the custody pertaining to who the child lives with. We as a society tend to automatically assume that mothers will automatically get primary physical custody while the dad is simply limited to some sort of weekend visitation. In the past, this was in fact very common, and it is still very common. However, we're seeing a trend towards more of joint parenting, and some dads having primary custody. I wholeheartedly believe that a child benefits from having both of their parents in their life. So I am a supporter of joint physical custody arrangements. As only a portion of our society agrees with that and has accepted the growing trend of joint parenting, it is important to position yourself if you are going to be seeking joint custody so that you have a better chance of winning joint custody. So today I'm going to be going over some tips to help you have a successful case if you're pursuing joint custody. My first tip is going to be sincere. If you want joint custody, your reason for wanting joint custody needs to be pure, and it should not be based on something corrupt, such as just wanting to hurt the other parent by taking the child away, or as an attempt to avoid some type of child support, because avoiding child support is not a solution to joint parenting, because actually in joint parenting scenarios, a lot of times there is actually still a child support obligation. So if you want joint custody, you should want it for pure reasons, like simply wanting to spend more time with your child more than 4 days out of the month. And you want to be a daily caregiver for that child. On more occasions than not, I have people come here, say they want joint custody, and the reasons aren't pure. And at the end of a case, your true intentions will come out. So if you don't really want if you don't really want joint physical custody, don't waste the court's time or your attorney time attempting to pursue that. My second tip for you is to be involved. Being involved with your child is a crucial step to a successful attempt at joint physical custody. If you have a child and the other parent is always the primary caregiver, then you need to start stepping it up before you file any legal action. If the other parent is always the one to do everything for the child, get the child up, take the child to school, get the child ready, pick them up, take them to appointments. Literally, sometimes in some scenarios, one parent does everything. If you want a chance at joint legal custody, you need to step up and be the parent who schedules the doctor's appointments, be the parent who takes the child to the appointments, be involved with the medical care of the child. If the child has some type of special asthmatic condition or blood condition, you need to know how to treat that child and don't rely on the other parent to teach you or to take care of everything. If the child is sick, you stay home from work. Don't always have the other parent taking off work. If there's parent-teacher conferences, you too need to make sure you attend those parent-teacher conferences and don't rely on the other parent to get all of your information. If the school sends out emails, you need to make sure you're on the email list. You shouldn't be solely dependent on somebody else to tell you what's going on in your child's life. So you need to go ahead and step up to the plate and start acting like a joint physical parent. Now, let me say this, within the era of social media, everyone looks like an amazing parent, but we do not rely on the social media images that you may paint yourself to be. So I encourage you to be the parent that you make yourself look like if you're not actually being that parent. Sometimes people just post pictures and bring them in court saying, oh, look, he or she does this or that, but that's all it is, it's a picture. So it's so much more to parenting than just posting it on social media. My third tip for you, and as I go through this, you guys can write questions. I'm going to answer every question that I get live at the end. So if you have questions pertaining to family law, not necessarily joint custody, you can feel free to go ahead and type them and I'll get to them at the end. Same thing for you over on Instagram. I'll answer your questions too. So my third tip is going to be having good communication. A crucial key to co-parenting and especially joint custody is having the ability to effectively communicate with the other parent. The reality is that you and the other parent will have to deal with each other for the rest of your child's life. If both of you are going to equally raise the child, there must be the ability to communicate effectively. Parents who are unable to communicate will not be able to co-parent well. My tip number 4 is you need to live close to the child's school or live close to the other parent. Location is very important when seeking joint custody. Parents who live close to each other or a parent who lives close to the child's school has a better chance of winning joint custody. In every case, we're looking to determine what is in the child's best interest. It is in the child's best interest to see both parents equally, absolutely. However, it may not be in the child's best interest to have to wake up 2 hours early because of the excessive drive to school from one parent's house to the other side of town. Because this causes a breakdown in the child's routine. The child may be tired from having to wake up early, etc. So if you are currently living with the other parent but planning to move, you need to be planning to move very close to the other parent. Or if your child goes to private school, you need to be planning to move near that child's school so that when we present to the court that we want a joint custody arrangement, we can say, oh, well, mom and dad both live near the school. The child is 20 minutes from both places. It's not a major disruption to the child's life. Tip number 5 is going to be having adequate living space. If you are seeking joint custody, then you need to have adequate space for a child. Ideally, the child or children will have their own room at your place that is set up for a child. This means a bed, dresser, closet with clothing. If you're seeking joint custody, this means that you don't expect your child to come with everything they need. If you're seeking joint custody, this means you're going to already have everything your child needs, and your child should literally be able to go from one place to your place and have everything they need, down to the toothbrush, to the underwear, to the socks. Literally, you need to have everything at your house with the exception of their homework for that day. If you live in a 1-bedroom apartment or something, you need to be looking at upgrading your lease to a 2-bedroom or a 3-bedroom, depending on how many children you have, if you're trying to pursue a joint custody arrangement. If you currently live with a roommate and don't have extra space for a child, you need to consider getting your own place or getting a bigger place. It is okay to have a roommate and have joint custody, but you need to make sure your roommate is appropriate to be around your child. So if your roommate, does drugs or anything like that, that's not going to be a good argument for your custody case. Tip number 6 is you need to put yourself in a position to have reasonable working hours if you're going to be pursuing joint custody, so that you have the availability to be able to care for your child 50% of the time. In doing so, you need to make accommodations to your work schedule to support a joint custody outcome. If you work overnight, it is obvious that your children cannot stay home each night unsupervised, so you need to talk to your company about switching to a day shift if that is possible. If you have to be at work at 6:30 in the morning, then you need to have a plan for how your kid's going to get up, get dressed, and get to school by 8 o'clock. If you don't get off work until 9 o'clock, what is your child going to do when they get out of school at 3 o'clock and after school care ends at 6 o'clock? You need to have a plan, and it needs to be able to be clearly laid out to a court if you're going to be pursuing joint custody. These things have to be addressed. The best schedules, in my opinion, for joint custody is typical 8 to 4, 9 to 5 schedules, so that you're able to take the kid to school and or pick up the kid from school, be there to do homework each night, make sure projects are done, and make sure the kid gets to school, eats breakfast, etc. Tip number 7, and this is the last tip, so start writing your questions if you have them, because I'm going right into questions after this. Number 7 is establish the parenting plan that you desire. Prior to ever filing a custody case or pursuing a custody case, you should try to voluntarily create the parenting time that you want and make that a consistent habit. This means if you want to have the child a few days each week, go ahead and start spending that time with the child now. Courts are very likely to maintain status quo of what parents are already doing, because if it's not broken, why fix it? So if you only see your child sporadically now, meaning once a month, whenever you feel like it, you should not expect to prevail in a joint custody case. Joint custody cases, and those parents who are successful at it, are already involved in their child's life way before they ever file the custody case. So if you're off Wednesday and Thursday of each week, get your kid Wednesday and Thursday and then keep them through the weekend. Just establish that pattern, because that's going to be the pattern that the court is likely to adopt in the final order. So those are the 7 big major tips that you need to make sure you have in line if you're going to be going for a joint custody type of arrangement, joint custody or primary physical. Honestly, either one of these tips will help both of them. Really, all of them together create the best argument. But if you can only do a few, then do them well. But the reality is, the kind of parent you are now, if you're not doing all these things now, it's going to be hard to convince the court later that you automatically, all of a sudden want to just step up and do all these awesome things. So go ahead and start now before you ever file something. So now I'm going to go into your questions. I see I already have some, but a few people, I got 2 questions that were emailed. Well, they were emailed to the office. So I'm going to answer those first. So Sheba K said, what age are children not required to have court-ordered visitation? According to Georgia law, if a child's a child, that means anybody under 18 or still in high school, they're subject to a court-ordered visitation. However, I have seen judges, when kids get a little bit older, 16, 17, 18 pre-high school graduation. The courts don't necessarily force them to do the visitation if they don't want to. However, they're still a child and they're still subject to the court order. So you as a mother or a father should still encourage the child to have time with the other parent. Kathy T says, if my child support order starts this month, can I collect back support from previous years? So Kathy called and she said that on a previous broadcast, I said that you can collect back child support for 7 years, but that is not true. I have not said that. You cannot get back support that way. If there's a court order in place, you are entitled to the court order amount. So if your support is starting this month, that's what you're entitled to. You can't back it up the 9 years of your daughter's life and reclaim that. That's why it's very important for mothers. If you want child support, file it when your child is little, a baby, versus waiting until your child is 10 because you just missed out on 10 years of child support that you can't go back and collect. Okay, so let me go to the current questions. Kayla. Okay, Instagram, I'm coming to you next. Kayla Taylor says, what if the mother of the child is keeping the child from the father, but the father is wanting joint custody to ensure him his time with the child? Will it hurt his chances of getting joint custody because he has not been able to be involved? We have all the proof of him trying to communicate and trying to be involved, but she does not allow him to have any contact with the child simply because she is mad he is not still in a relationship with her. Kayla, this is very, very common. So what's going to affect his chance at joint custody is how long he waits to do something about this. So if she's been doing this a year or two, the question the court has is, why did you wait 2 years to file legitimation? If they weren't married, he needs to file legitimation action immediately and show the court that he's serious about being in his child's life. He can't just keep accepting her behavior. It's completely unacceptable, but she's well within her rights. If the child was born out of wedlock, he does not have any rights to the child until he pursues those rights. And so he has not pursued those rights, then she's well within her rights to say no. It doesn't sound right. It's not fair, but it is the law. So if he wants to make a change, he needs to go ahead and file an action immediately. Okay, let me hop over to Instagram. Okay. Can Only Be Me says, what if we are not married and he is not on the birth certificate? Can he take me to court even if he is not helping me to pay anything? And that's from Can Only Be Me. Yes, if you are not married and he's not on the birth certificate, what he needs to do is to file a legitimation action before he can take you to court. And it's essentially the legitimation action is taking you to court. And in that action, you could request child support so that he can help you pay for something. And depending on how old the child is, you can also get reimbursed for your birthing expenses if the child is still young and you have proof of those expenses. So yes, he can take you to court, but he has to file the actions first. If he doesn't file anything and you still need financial support, you should consider filing an establishment of child support petition. Okay, I'm going to hop back over to Facebook. John says, I'm seeking joint custody of my daughters, but I was advised that the judge in the county that the mother reside in may look down on the fact that I live in a different county. I am heavily involved with my children. I pick up and drop off my daughters every morning for school. I also work 5 minutes from their school and live 20 minutes from their current home. Should I still seek joint custody? John, I would definitely say you should seek joint custody in this scenario because you work 5 minutes from the school. So you're going over there every single day anyway, and you have to be at work at a certain time. You're already doing this pattern of driving 20 minutes to pick them up and then driving all the way back to your house, by your house, to take them to school. So you've already established that pattern. So I would absolutely proceed forward on a joint custody request. The question is going to be how many overnights they're going to be staying with you. Thank you, Bailey. I see your comment. Okay. Rosalind, can I do a remodification after 2 years based on the fact he lied about his income? Can I request tax returns he submitted? Hey, Rosalind, yes, I'm assuming you're talking about a child support modification. You can do it after 2 years. And yes, once we file the action, we are entitled to do what's called discovery. And that's a legal review of his financial documents. We can check his bank records, tax returns, etc., to make sure we try to properly calculate his money. So if it's been 2 years, you can't file a modification. Okay, Antonio, I'm trying to fight joint custody for my son, but the mother is not trying to receive the paper. I've been in my son's life since the day he was born, and the mother stay together, but now every time the process server comes to the auntie house to serve her, the auntie either saying she's not home or she does not live there. Can I have her serve any other way if she's not trying to receive the paper? My son is only 1 year old. Okay, first of all, Antonio, good job of filing these papers while your son is so young, because that's going to ensure that you actually have a lifelong relationship with your son. That's number one. Number two, absolutely. There is another way to serve her. Instead of serving her by the sheriff, you need to use a private process server. We have some great ones that we use here. So if you need representation, give us a call and we'll make sure she gets served. But you're going to have to serve her to get any action, because that's going to start the clock for things done. If she's not served, the court can't do anything yet. Okay, Rosalind says, father lied on content doc regarding visitation. What do you mean that he lied on a content doc regarding visitation? Are you saying he said he has visitation that he doesn't? And I'm not sure exactly what you're getting at. So kind of clarify that for me. Raniqua says, my husband is paying child support for his children and has it deducted from his paycheck. He has been told he has to have surgery on his knee and that he will be out of work for 3 months. Is it possible to have the orders paused for that time, as he will not have any income? This knee surgery is a need and seriously affects his ability to earn income for the future. Unfortunately, Raniqua, no, his child support will not be suspended for this 3-month period. Regardless of the situation, both parents are required to take care of those children regardless. So for example, if his children lived with him and he had the surgery, he would still be expected to clothe, feed, and provide for his children, whether or not he had a steady income or not. So you're not going to be able to pause it. Now, if he had a more severe situation, like he was going to be out of work for a year or something, then maybe he should consider filing a modification of child support. But for a 3-month pause, no, there's not going to be any pause. And depending on how far the surgery is, you may want to be putting money aside to make sure he's able to make that obligation as well as the household obligations while he's not working. Mary, what if the mother of the child filed for divorce and the father was never notified for a court hearing and the mother was given sole custody of the child? How would a father try to get joint custody? Really good question, Mary, because this happens a lot. So let's see. Okay, so when this happens, people say, I didn't know about the court date. I didn't know about the divorce. And if that is true, we can file a motion to set aside the divorce, meaning wiping it out altogether and doing it over. But sometimes, and a lot of times, when we start looking into these cases, we actually find proof that you did know about the court hearing. They sent you notice to this address. It was deemed received, or some other notion that completely prevents us from going back and setting it aside. So he just needs to be really sure that he did not have notice, that he was not served with anything. It just depends. He should probably come in for a consultation to see if we can turn it around. But if we're not able to set it aside, the other option we can do is file a modification of custody, requesting it to change from sole custody to joint custody, depending on how involved he is with the children, to see if we have that argument. If she has sole custody, he probably has no visitation or very limited visitation. So even if we can't get joint custody right away, we can step him up and get him more visitation, and that'll be a baby step to ultimately getting that joint custody. So sometimes we have to baby step it to get there, but we'll get there. It just takes time. Let me check Instagram, see if anybody's asked anything. Okay, what is the process for legitimating? Only a father can legitimate, and you have to file it in the county where the mother and the child lives. Okay, my Instagram is pausing due to poor connection, so I'm going to keep talking because they'll have to catch this on Facebook. To legitimate, you file in the county with mother and child, and then you say what you want, basically, what kind of custody, and then go to court. Okay. Tamara have a situation where the mother is, quote unquote, trying to get the father taken off child support, but was told due to the fact that the baby is on family Medicaid with the mom, the father can't be taken off child support unless the mom or baby comes off Medicaid, but the father wants to get legal joint custody. Is that possible? And will the fact that he is on child support affect his chances of custody? That is true. If a mother or a father is getting state assistance, the other parent is going to stay on child support. And even though she's taking him off of child support, what she's doing is taking him out of the child support system. That does not alleviate his responsibility for paying child support. It just takes him out of the system of it, but he'll still have child support. The fact that he's on child support, affect his chances for joint custody. It only helps his chances. I mean, because first of all, you can't say you want joint legal custody and you don't provide any financial support for your child. It don't work like that. So if you're paying child support and supporting your child without a court telling you to support your child, that looks awesome when you're pursuing custody, because it looks like you're genuinely interested in making sure your child is well cared for and taken care of. Oh, thank you, Lori. Okay, Johnny. Okay, Instagram, you guys are back up. Sorry, my phone connection was off, but I did talk about legitimation, and I'll post a link to this video after this so you guys can go back and catch it. Okay, Johnny says, I have my legitimation papers for both of my kids. Would it be difficult to get joint custody of them, being that I'm in Georgia and they're in Alabama? Johnny, I don't know anything about Alabama and how they do over there. And your custody case will have to be in Alabama because that's where they live. Michelle says, what exactly does Section E that states that the parties cannot agree mother has final decision making means? Okay, so guys, what she's referring to is what's called a parenting plan that's filed in every case. And in that parenting plan, under the joint legal custody column, there's 4 categories that there's decision making authority. That's education, non-emergency health care, religion, and extracurricular activities. So when you have joint legal custody, those are the 4 categories. So one parent can decide on all those factors, or if you have joint, one parent may say, well, I'm going to have decision making on extracurricular and education, and you decide on medical and non-emergency health, medical and religious, and or 3 and 1 or whatever. So when Section E says that if the parties are joint, because on all 4 of those things, parties can share decision-making authority. So on the boxes, it'll be joint, checked all the way down versus mom or dad. So if it's joint, if you have joint decision-making on, say, education, and mom wants kid to go to private school A, and dad wants kid to go to private school B, well, that obviously doesn't work. The kid can't go to 2 schools. And so what Section E says is the parties cannot agree. And your parenting plan says mother has final decision making. So that means after we tried to work this out, we tried to talk about it, the kid is going to school A because that's the school mom wants the kid to go to. Section E can also say dad has time making authority. And so if that were the case, dad would have the final say. But we look at it for each category. So mom may decide on one thing and dad may decide on another. Ooh, okay. Iman says, my child's father is always threatening me in terms of custody for my child. He only gets his daughter every other weekend, if that, and he thinks he can show up whenever he wants. And I've told him he doesn't by a certain time, then he can come get her the next day at the time given. He says I am denying him his custody when he isn't legitimized and doesn't help ask or talk to his daughter any other day, even so much as not even asking for her for Thanksgiving. He has nothing for our child, no clothes, no toys, but he does have a better paying job that could affect me in the long run. I have done everything for my child since the beginning and just wondering where I would stand if he did a random foul like he's been saying. He also fails to communicate, always calling me derogatory names. And where his girlfriend curses me out, what should I do? Okay. Inman, I did a video maybe 2 weeks ago called What Unmarried Mothers Need to Know About Custody. You need to go watch that video in detail because it's really going to help your life. The easy answer is he doesn't have any rights to this child because he didn't legitimate. And so I do commend you for allowing him to have visitation with your daughter, even though he doesn't have any rights. But you need to make sure that you let him know who's the boss and who's in control in this situation, because he doesn't have any rights. And whatever you give him, he should be thankful for. And he'll have to go and file something. If he does go and file something based on his pattern and his history, he will not be successful at joint custody just based on these facts. And if he has a better paying job, you should get sufficient child support. Okay, Rosalind, father lied on contempt form emailed to me regarding visitation. Okay, so if he filed a contempt, Rosalind, make sure you file an answer asserting what your position is. And when you go to court, make sure you bring those text messages. Raniqua, can the amount of child support be reduced the way his income will be for that period of time? The amount he pays is excessive. Paying that amount without an income will lead to a definite hardship. I understand that he has to care for the child live with us. In this case, we scale back. Can the other parent scale back too? You can't do a temporary modification in an action that is not pending. And so, no, I'm sorry. He may need to take out a loan or something of that nature, but you're not going to be able to do a temporary modification for 3 months, because any judge, first of all, when you file it, you won't even get to court for 3 months. By the time you get to court, he'll be back working. And so there's just no remedy for this. And I apologize. I wish I could tell you something, but I don't want to lie to you. And that's just as honest as I can be about that. Lori says, where can you find out if the father has done an administrative legitimation? Lori, you can check the Department of Vital Records, the same place you go for birth certificates and marriage certificates, etc. Administrative legitimations have been outlawed as of July 1st, 2016. So if the child was born late 2016 or 2017, there's definitely no administrative legitimation because we don't do them anymore. But if the child was born between 2008 and 2016, he may have. You're funny, Brian. Try not to eat meat. Okay, let me check Instagram and see if I have any more questions. If you guys have any more questions, go ahead and type them. Okay, no more questions on Instagram. And so okay, so I think I covered everything. Oh, nope. We always do that. Get ready to finish, and then you guys pop up with these questions. Okay. So Tamika, my husband had joint custody and a parenting plan, but the mother keeps denying visitation, pays child support, comes out of his check every 2 weeks, and has also come out since he was 2 years old, not behind at all. He's supposed to get him every other weekend and all holidays, but she keeps saying they have plans when we have to pick him up. He's now 14 years old. Please advise. Okay, Tamika, what your husband needs to do is enforce this order. So moms and dads, if there is a court order saying that somebody has parenting time with your child, it is not up for discussion. I don't care if you made plans, you're about to lose your money on your plans, because the other parent is entitled by law to the child at that time. And you are not in a position to deny that visitation without extreme recourse. Now, when we have mothers or fathers who do this consistently, we'll ask for incarceration. You want to deny me 20 days of visitation? Well, you can go be locked up for 20 days. And so you can see what that 20 days feels like. It is unacceptable to deny children from a parent who has court-ordered time. So, Tamika, my answer to you, what your husband needs to do is file a contempt action immediately. And then if he can come and talk to us about it, and we'll see if he's able to file a modification. The child is 14, so he's of age of election to decide who he wants to live with, who he or she wants to live with. And that may need to be something that's considered. But your husband should not let another holiday go by or another weekend go by without demanding that he have his child. Now, if he's supposed to get the child this Christmas, he need to send a text message today, send an email today saying, hey, X, I have visitation per this court order. I'm going to be picking him up on this day. And keep doing it and let her keep denying it, because that's only going to make his contempt action look better. Kezia, does a child who has never been around his father and their family have to see them by themselves from the very beginning? There could be separation issues and they are still considered strangers to us. I would really like them to come to our home at the beginning 1 or 2 hours just until he gets used to them. Kezia, this depends on how old your kids are, but we do what's called step plans. If we have a parent who doesn't really know his children, we gradually introduce them to the children in increments of usually 4 to 6 hours at a time before we go into full overnight visits. Lori, child born in 2010, what rights does the administrative legitimation give? It doesn't give any custody rights, like specifically laid out, which is, I think, why we got rid of it, because it was just too confusing. But if the dad dies or something, the child is considered a legal heir and can legally inherit from the father, and he's technically got legal rights and being able to make a decision on his health care and schooling and stuff. But the confusion with it is that there's no court order. So if there is an administrative legitimation for those clients that come in with that, for my male clients, it really doesn't help us, because we still have to file a petition to determine custody and visitation. We just don't have to argue about the legitimation already being granted. My daughter's father's trying to get joint custody, but he lives in North Carolina. Will he get joint custody? That doesn't even make sense. Like, unless your kid's a baby and doesn't go to school, because you can't share custody 2 states apart, unless, you know, some lawyers try to slide in here with joint custody and he get the full summer. Okay, if you want to call it that, if you know, words mean a lot to you, but that's not really joint custody. Joint custody is when you share almost 50-50. Sometimes it's, you know, one parent might have 55% of the time, but it's close to 50. That's not even realistic. Lori, do you need a lawyer to file for a court-ordered passport? Father not signed paperwork. Lori, I used to tell people some stuff they didn't need a lawyer on, but now those people that I tell them they don't need a lawyer, and then they go do it themselves and they come back and it's a lot for me to fix. Now I just say always get a lawyer if you can afford it, especially for a passport. It's not that expensive to get a lawyer for. So I would say get it, yeah. But if you can't, you can do it on your own. I just don't know what you'll run into. Michelle says, check my Instagram. Okay. Michelle says, if I had an order that was modified and he has to cease the use of drugs and alcohol around the kids, and he has started back, is it wrong to keep the kids away? He threatened the police will come to my house and take them because I have no proof, but I smell the marijuana and my son is asthmatic, which is why the judge said no drugs. Okay, so very doubtful that the police are going to make you turn him over, because you know what? In all the situations they should turn the kids over, they don't. They're going to say, this is a civil matter and you need to take up with civil courts, not a criminal matter. So they're not going to do anything. I would, if I thought somebody was under the influence of drugs, they would have no parts of being around my child. But it sounds like what you need to do is go back to court to modify the visitation, given that he's back on drugs, so that he doesn't even have the right to show up to try to get these kids. But if he's smelling like marijuana and alcohol, I would not release my children to him. And when you go back for the visitation, ask the court to put some kind of provision in there about him having to pass a drug test before he gets the kids. Adela, what county is Woodstock? We might go out there for the right price. Brandy, traveling outside the country, unwed in Georgia. My son has a passport, but the father is on the birth certificate. I'm required to have either the parent who's been MIA for 7 years have written consent or have a court order for legal custody. The feedback I'm getting is that in Georgia, I have legal custody. This doesn't seem to hold true for international travels. Can I get a judge to give me a legal custody order? So yeah, so this is right. Oh gosh. So my phone just died for my Instagram people. How terrible is that? Okay, so you don't need a custody order because you already have custody. So when you're trying to get a birth certificate, you need to file a petition. It's called a petition for a court-ordered court-ordered passport for a minor, and get the judge to sign it that way, and then you can take that and get the passport. Clatanya, my husband has a GAL, and the GAL has made comments that my husband is lucky he is getting anything. Is there something can be done against the GAL? Well, that's going to depend on what the GAL is finding in their investigation. We've had some problems with guardian ad litems. A GAL, for those who don't know, is called a guardian ad litem. That's a child-appointed custody advocate. So he may need to come in for an appointment and see if he can turn things around. Tiffany, my husband and I would like more time with his daughter. We filed for joint custody when she was 6 months, and we're only given every other weekend and holidays every other year. She is now 3. Would it be in our best interest to file for joint custody again? Tiffany, I'm curious if you had a lawyer at that time, just for my own knowledge. But the problem here is that you have a custody order that's 3 years old, where you were granted basically weekend visitation. In order to modify custody, it has to be a material change in circumstance that affects the welfare of the child. And if nothing has changed, then you don't meet the requirements needed to change it from mom having primary custody to you guys having joint custody. And so the best thing I could recommend to you with these limited facts is to file for a modification of visitation, because you don't have to meet a statutory element to file that. You can just file that for whatever reason. And so in a modification of visitation, we can try to get him more time outside of the every other weekend. And so instead of his weekend, say, being Friday through Sunday, we may try to extend the weekend from Thursday to Monday, and then a weeknight on alternating weeks or something like that. That'll double his time. Okay. Lori, how long does the process take? And she's talking about getting a passport order, depending on what county you're filing in, but a couple months. Adela, we've done stuff in Cherokee County, but we don't, yeah, you're right. We don't really like to go there. Lori says, never mind, I'm just going to hurry up. Call us, girl, 678-973-2803. It'd be easy for us to do because we do it in our sleep. Femi, call us if you need a lawyer. She says, I live in Kentucky and my children are in New York City. Their father would not let. Okay. Femi, are you a female or a male? It's not like you're saying that your kids' fathers have your kids. That ain't right. You're female. Is there a custody order in place giving their father rights? Clatanya, yes, we work in Henry County. We have lots of cases in Henry County. Paige, if the child is in Louisiana, jurisdiction is proper for Louisiana. So you're going to need a Louisiana lawyer. I'm just waiting on Femi to respond. I want to see what's going on here, why she don't have her kids. Type fast, girl. Okay. Yes, but I have rights to see them. Okay. So you said something about him being in New York. So if the kids are also in New York, then New York is going to be the jurisdiction, or the previous state that entered the order, depending on if that state maintained jurisdiction. So I'm probably not going to be able to help you with that. But just an overall advice is going to be file a contempt action in the initial county that the order was entered. If he's denying you your custody rights, you need to make sure that you're doing whatever you need to do to enforce those rights since they were given to you. Okay, I think I have answered all the questions. So if you are having a custody situation and you need legal representation, which I always recommend in custody cases, this is not something that you do on your own. It can be very complex. And you want to come in and talk to us about your case and whether or not you have a good case, you can reach us at 678-973-2803. You can find us online at farrellfirm.com, and you can book appointments through our website, or you can just give us a call. Sometimes that's a little bit easier. Our consultations are $150. They give you an hour with myself or one of the other attorneys here in the office. Okay. The consult is $150. I see some of you asking about the price. Aiden. Okay. So what you want to do, Aiden, she said, what do you do to request a change of venue? What you want to do is an order to domesticate. I moved to Georgia. Yeah, so neither one of you are in San Diego anymore. So if you and the child live here, you can order to domesticate it here and file a petition to domesticate it here in Georgia, so Georgia can take up the issue. That phone number again is 678-973-2803. I'm going to put it on the screen for you guys. Okay. All right. I'm going to let you guys go. It's Friday. I hope y'all have a good weekend. I will be back here next week. Same time, maybe. I may do a little bit later. I think you guys like the later broadcast, but I'll post what time we're going live. So I'll see you guys then. You guys have a blessed, safe weekend.